Jerry, you were live.
Okay. Good evening, everyone. Welcome to the City of Annapolis Board of Appeals regular virtual meeting for June 7th, 2022. This meeting is being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher, Chairman of the board. This virtual format allows the public to observe the meeting through the video link and submit written comments through the City of Annapolis website. Links to the YouTube channel, the comment form on the city's website, and to the city's database for information relating to the cases to be heard tonight may be found on the agenda for tonight's meeting. The folks that you see on the screen are members of the Board of Appeals. When a case is called, representatives of the parties to the case will also appear on the screen. Also participating in the meeting tonight are counsel to the board, Cheryl Woods. Our technician managing the broadcast tonight is Julian Jock. Also participating may be representatives of the city, including Joel Braithwaite, Assistant City Attorney, and counsel to the Department of Planning and Zoning, and Jacqueline Rouse, liaison to the board, as well as one or more other members of the planning staff. Any public comments received by noon today, the matters before the board this evening have been provided to the board and the parties and will be made part of the record. The public may also submit comments on any case continued from tonight to a future hearing date until noon on the day that the hearing is resumed. And that day will be June 15th. We ask everyone but members of the board to mute their audio. If anyone else wishes to speak during the meeting, please raise your hand and I will recognize you. Let me remind everyone that communications with the board about any case by anyone other than a party to the case must go through the city's comment form. All communications by parties to a case must go through the board liaison, Jackie Rouse. No one should contact any member of the board directly about any case at any time. So we'll begin by calling the roll. And it looks like I'll be doing that today. Mr. Zazali.
Present.
Mr. Walsh.
Present.
Dr. Chen.
Present.
Mr. Burnett. And Mr. Dews. So we have a quorum and we will proceed to the evening's business. Have the members of the board had a chance to review the agenda? And if so, do we have any corrections or additions? All right, may I have a motion to approve the agenda?
I move.
Second.
All in favor?
Aye.
Aye.
All right, thank you. The first item on our agenda is the approval of the minutes for May 18, 2022. Are there any corrections or additions for the minutes? All right, may I have a motion to approve the minutes?
So moved.
Is there a second?
Second.
All in favor?
Aye.
All right, thank you all very much. All right, Julian, you may admit the folks here on the Eastport SPD 2018-006, please. How are we doing, Julian? Do we have,
Mr. Chair, they're all here.
they're all here, good. I don't see them, but I
Heidi and Alan on the screen, and then Charles and Steve are, I think, with their cameras off currently.
My client, Mr. Rogers, is also here. I don't know if you want him as a panelist or a member.
He's forward as a panel. He just has his camera off and he's muted. as is Charles Henney.
All right, well, we'll thank the parties for their thoughtful submissions on the preliminary issues. This is about preliminary matters in the remand of the circuit court, remand from the circuit court for Anne Arundel County of the board's decision in the appeal from the certification of adequate public facilities by the Director of Planning and Zoning and SDP 2018-006. Question before the board is what happens next, and the parties have submitted their thoughts on that, and we thank them for that. And we'll offer the parties a brief opportunity to orally supplement their submissions if they think that's necessary. I just remind them that the board members have read their written submissions and we understand them. We'll also have an opportunity for members of the board to ask questions if they have any. Let me ask counsel for the parties. Have any of the parties appealed the circuit court ruling to the Court of Special Appeals? Ms. Howard?
No, I have not.
Uh,
Mr. On behalf of the clients. I guess with the Board of Appeals, we're still the respondents here, I suppose, applicant and respondent. And that
well,
would be, and we would be the respondents, just to different titles, different names, different courts. Respondents have not appealed.
Okay, thank you. And the applicants?
Chairman Alan Hyatt for the applicants, we have not appealed.
The city, do we have anyone from the city? From the
The
of
city has
Springfield?
not appealed.
Thank you, Mr. Braithwaite. Okay, are any of the counsel for the parties feel the need to supplement what they've submitted in writing? Great. Questions? Sorry,
Not at this time, no.
questions from the board? Dr. Chan?
I thought the submissions were very straightforward. I would be interested in the respondents, if they could elaborate a little bit about the desire to be at the table for discussions of an additional mitigation agreement. What would you see your role as being? And how would you like that to look?
The code does provide the procedure on how a mitigation plan would proceed. And I'm not asking that procedure to change. What we're asking for instead is that there be what I described it as transparency for the public, so that that these meetings don't occur behind closed doors, that the members of the public or the respondents be notified of any meeting between the city and the applicant, because there is required to be a meeting, that the respondents have the opportunity to observe and to offer input. There's obviously not a vote or any determinative role, but just as part of the process to discuss or point out what may be difficulties or problems, so that in the future, any decision, there might be some input and those issues can be addressed. I also asked, importantly, that these meetings be documented as part of the record, so that the city is to provide, the directors of the departments are to provide what they believe would be conditions, proper mitigation conditions, and that they submit in writing their request or recommendations for proper mitigation conditions, and that the respondent then the applicants provide a written proposal or response as to their position on what should be provided in a mitigation plan, so that their positions are presented, and then proceed with the negotiation that goes forward, and that any final mitigation plan then also be included on the record. I think that's what the process is outlined to be in the code. And I believe that that should be formalized in this case, given that there was no record for both the board and the Court of Appeals noted that that any reviewing body has to guess at what the city believed to be the appropriate mitigation conditions and what the ultimate negotiated position was. So I believe that would address those issues addressed by both the board as well as the court presented in the court's decision.
Any other questions, Dr. Chen?
I have one other question for both councils. With regard to the traffic study, I would just like to understand your positions on the existing study, the age of the study, the possible need to have it redone, because it is now 5 years old, I think.
I understand it is 5 years old and it would have been expired. I think the difficulty is board members, as Ali had pointed out, that it's still during the pandemic when we are today, remote hearings and people are remote work, and maybe it's not representative of the traffic conditions that would be normal non-pandemic traffic conditions. I think the traffic study did determine, and I think everybody, the courts and this board acknowledged or did, even with the limitations on it, that there are certain intersections that are failing. The non-signalized intersections of Monroe and Americana were failing, and that there was the difficulty or the failing within the evening rush hour of the Tyler and Hilltop, Bay Ridge and Hilltop. So I think that part of the study is important, but there needs to be a professional engineering recommendation as to how to mitigate the traffic problem. Their one recommendation in the report was not adopted. Two of them, I take that back. The signalized timing of the Hilltop and Bay Ridge Avenue intersection was recommended, but the other recommendation for a designated left and right turn lane at Americana and Bay Ridge was the only recommendation, and that was determined that it was not feasible because of the necessary turning radius, so that there is no recommendation of mitigation by a traffic engineer or professional, and that the city, as I understand it, does not have a traffic engineer on its staff. And as such, there is really no traffic engineer or professional to make the recommendations as to what is appropriate to mitigate. I think that the APF procedure requires that a traffic study be done so that there are traffic engineers and professionals that make the recommendations. In the absence of that, respondents would note that there needs to be either a supplemental report from a traffic engineer to recommend the appropriate mitigation to address the failing. And it's not just the Americana. Monroe was never addressed in any of the recommendations. It was an E or F intersection. So that that needs to be done. As you recall, during the argument, there was the position that, well, there's also going to be a stop sign. So we're asking for a stop sign warrant analysis at the intersection of Bay Ridge and Chesapeake, but there was never any traffic engineer that would recommend, that could say that it could be done. It just was, maybe it will have some impact. And so while I say that it's speculative, I think that there needs to be a directive to say that an engineer, certified traffic engineer, needs to provide the recommendation pursuant to the code, the way the code requires, a traffic study to be done by an engineer. An engineer needs to address that problem because that report does not have any proper mitigation recommendations. And so I recommend that. And the second part of that, I recommend that if there is a mitigation plan that relies on any kind of warrant analysis that needs to be done to see if the stop sign warrant analysis or a traffic light or anything else where there needs to be a warrant analysis, which is a preliminary study as to the feasibility of using that, never mind whether it could or could not work. I think the court's decision plus the board's decision is that a warrant analysis doesn't require that that be done. It's kind of speculative. It may or may not work. So the respondents would ask that if there is any recommended as part of any mitigation plan, a stop sign warrant analysis, a traffic warrant analysis, or anything in there that requires preliminary determination that be done before it's relied on or included in any mitigation plan, so that we can avoid that same pitfall that we had before with speculative, unenforceable.
I think you explained that in your written submission as well. Anything else, Dr. Chen?
I don't know if Mr. Hyatt has any comments.
We're going to ask him right now.
I'm sorry.
We're going to ask Mr. Hyatt right now to respond to your question.
Oh, okay.
Thank you. The city does have a process for studies. There's a RFP that is created, and the respond, and the city makes the determination as to who is hired. There are guidelines, so there's nothing that this board needs to direct the city to do. Your question is, is there going to be further study? And it's something that we are looking at carefully right now, because there may be a need to update the traffic counts. They're old, they're several years old, and we're going to take a look at that. But traffic, stormwater, police, our intention is to meet with the departments, which is called for under the code. I mean, it's very clear what the procedure is. And you can be sure, if we want to go forward and have a successful project, that we will do our best to make sure there's proper documentation, because this board needs to see what's called substantial evidence that's in front of the departments. If you don't see it, which you didn't see before, then we're going to spin our wheels, so to speak. So our expectation is that if we are able to reach a mitigation plan, then there's going to have to be documentation, proper analysis, and evaluation. And because we certainly expect another appeal, it's just the way it seems to be. And it will ultimately be back in front of the board. And if it is, we certainly want to have substantial evidence to support any decisions made by the departments. And we don't want to do the same thing again and come back without some difference. I mean, I don't think there's much for the board to do really tonight. You've already made your recommendations, and you've sent it back. There's 3 criteria that have been sent back to the departments. You've made your comments with respect to those, and I think that's the obligation of the applicant, to talk to the departments and see if there's a better plan to come back with.
Thank you, Mr. Hyatt. All right, Mr. Zazali, any questions from you?
Mine's really one just for the city, and the answer I'm perfectly satisfied with the answer that we're looking into it. I'll preempt that. But the one regarding the full-time police count is not something that it's in the chief of police ability to simply wave a wand and have. Is the city aware of this other than the planning department? And do you have a strategy to mitigate on behalf of the applicant and in the order from the court?
We'll have to if the plan is going to be successful. So that's my response is that we'll look into it and we'll see what mitigation is practical or based on the situation, and we come up with a solution if one exists.
Okay,
All right, anything else from you, Mr. Zazali?
that's all. Thank you.
Mr. Walsh?
No, Mr. Chairman, I'm fine.
Okay. All right, if you will bear with me, let me tell you what I think we ought to do and why, and then we'll see if you agree with that. I think the applicants and the respondents both misunderstand the limits of the board's jurisdiction in this appeal. The board has jurisdiction to decide appeals from decisions of the director on an on-the-record basis. When the first appeal in this matter was heard, we decided that the director had erred in granting the certificate because we found a number of facilities were not adequate. So we vacated the certificate of adequacy. The applicants in the city reached an agreement on a mitigation plan that they believe cured the inadequacies. The director issued a new certificate. The appellants appealed, and we found that the mitigation failed to achieve adequacy as to 5 facilities. So we again vacated this certificate. The applicants and the respondents appealed to the circuit court. Court reversed the board's decision as to 2 of the 5 and affirmed the board's decision as to the remaining 3. So it's now the law that the board was correct in determining that 3 facilities were inadequate. And that being the case, I think the board has no other option but to reaffirm its decision to vacate the certificate. So the applicants will decide what they want to do next, assuming they negotiate another mitigation agreement. The director issues another certificate. Appellants may appeal again if they find it lacking. So the board ruled during the hearings that that in an appeal of the adequate public facility certificate, we, the board, would not insert ourselves into the proceedings before the Department of the Environment and the EPA concerning the remediation of the pollution from the former gas station. In any case, those assertions relate to the adequacy of the stormwater facility. And the board is already held, and the court has affirmed that the stormwater facility is inadequate. So that's going to have to be addressed. The board has confidence that the director will not issue a certificate of occupancy for a project in violation of an agreement with the Department of the Environment or EPA. If the director does, appellants can appeal that decision as well. So as to the suggestion that the board order greater transparency in the handling of a renewed application or direct the heads of the city departments to take certain actions during certain time periods in connection with reconsideration of the application, the board really has no power to direct the parties to include the appellants in the negotiations or otherwise insert itself into the director's processing of the application as long as it meets the statutory rules, and no one has suggested that it doesn't. So my inclination would be to entertain a motion that the board will enter an order reaffirming vacation of the certificate on the grounds that police, traffic, and stormwater facilities are inadequate. And from there, it'll be up to the applicants to make another attempt at remediation if that's what they choose to do. So any thoughts from my colleagues on that?
Mr. Chairman, I think that you gave a very fair interpretation of what our powers are in this process, and I support that motion when and if it's brought.
Mr. Zazali?
You've succinctly summarized the last 3 years in 45 seconds or less. And with that, I will allow Dr. Chen to make the motion in case she has one more thing to add.
Yes, Mr. Chairman, I think you did succinctly summarize the last 3 years. I do agree. The reason I asked the questions that I asked was I wanted to hear out both parties fully on what I considered to be 2 important topics, but
Sure, of course.
yeah, so I move that that the board vacate the certificate and or reaffirm, excuse me, the vacation of the certificate under the police, stormwater, and traffic, and that we remand it back to the,
We don't even have to do that.
oh, we don't even have to do that.
You can just say period.
Okay, period.
Second.
All in favor?
Aye.
Great. Okay, well, thank you, Mr. Hyatt, Mr. Braithwaite, Ms. Halleck, for your participation and your patience. And
I'd like to ask a question in terms of the schedule. I do recall that there was something in the code about how long the parties have to reach an agreement, and I'd ask the city to help.
that's not the board's problem. Work that out with the city. If they don't do what they're supposed to do on time, it'll have whatever consequences it has.
I understand that, and that's why I addressed the schedule, and I was just saying that if, for example, that the time frame for the city to act on any application or mitigation plan is 30 to 60 days, and there needs to be a thorough investigation of, for example, of the traffic, as I use that example. Can the board and does the board have the capacity to allow additional time under the requirements?
I don't know. I mean, that's why your clients pay you top money to figure out those questions for them. So unless there's some other comment, thank you all very much. And we'll move on to the next case. Julian, would you like to bring in the parties to variance 2021-008, please?
So, Mr. Chairman, I remind you that I need to recuse myself from this case.
Yeah. Do you want to, can you hang out in the waiting room till we get to the next one? Because we might.
Yeah,
We might
yes.
move to the next one. So Julian, can you put Dr. Chen in the waiting room?
Mr. Chair. Hey, Mr. Chair, you have Mr. Sullivan and Mr. and Mrs. Taylor are here with us.
Okay. Let's see, I want to make sure I have the right file here.
Oh, wait, Bob.
Yeah, but we've got a special exception. Oh, wait.
Oh, right you are.
Okay, so this is variance. It's got 2 special exception 08s, one at 21 and one at 22. Let's see, so the address of this property is 416. Okay, so that's the one. Got it. Right. My colleagues have their hands on the right files. Variance 2021-008, request by Joseph and Elizabeth Taylor. We good? We all on the same case? Okay. So this is variance 2021-008, application for a reduction of side yard setbacks to the Taylor's house at 416 Chesapeake Avenue. It involves the demolition of an old house, reconstruction on the existing setbacks, and a two-story addition at the rear of the house matching the side yard setbacks of the original house. There's also construction of an auxiliary structure at the back. In the backyard, but no variance is requested with respect to that. Is that right, Mr. Smith?
That's correct, Mr. Chairman.
So you just pointed that out to us because it's on the plans and it's a matter of information.
Yes, sir.
Yeah, okay. All right, will everyone who proposes to give evidence on this application, please listen and affirm or not this oath. I swear or affirm, subject to the penalties for perjury, that any evidence I may give in this matter will be true and correct to the best of my knowledge. So those who may testify, please acknowledge your agreement. Do we have anyone who's going to testify?
Yeah, I'm sorry, I'm unmuted. I'm Tobias Sullivan. I'm the architect for the project, and I affirm your.
All right. So, Mr. Smith, will you be introducing this for the city?
Yes, sir.
Please go ahead. You have the floor.
For the record, Mr. Chairman and members of the board, Thomas Smith, Chief of Current Planning for the City of Annapolis. This is variance case VAR 2021-006, located at 416 Chesapeake Avenue. The board should have received a staff report from the department dated April 26th, 2022, architectural plans from the applicant, from Tobias Sullivan Architects, and I believe I included some photographs of the structure, really documenting the decay as part of the reason for the demolition. So this structure is beyond repair, so to speak. The city has officially condemned it, and the applicant submitted a revised neighborhood conservation site design to demolish the existing structure and replace it with a replica with a rearward addition. The lot itself is only 20 feet wide. The structure is 16 feet wide today that sits there. It has been there since approximately 1905, and that non-conforming to today's code. And to replace it in the exact same location as a replica, it requires variances to both side yard setbacks. The side yard setback in the R2NC is 6 feet. The current left side is 3.5, and the right side is actually 0. So the applicant requests to vary those setbacks to those existing dimensions.
Okay. We'll give the applicants an opportunity to add any other information they think we need, but reminding them that we have read the recommendation from the Planning and Zoning Department, as well as all the attachments and the application itself. So please be as brief if you can. If you have something to say, we'd like to hear it.
I'll chime in just real quickly. The history of this project was the Taylors bought the property with the intent to, excuse me, with the intent to renovate it, and we had gotten all the way through the neighborhood conservation design process, and were told by city to go ahead and file for the building permit. We had gotten approval or recommendation for approval from ECA. And then when we got into the structure, you know, I think the photos speak for themselves on pages 1 and 2 of the package. There just really wasn't anything left to save. So from a, not even from a running horse, from a walking horse, this would be the exact same project for all intents and purposes that we had already gotten approval for, but now with a modern and safe structure rather than, what's left here. So I'm happy to answer other questions. Hopefully this isn't too controversial.
Okay, Mr. Smith, has the city determined that there's been proper notice and posting?
Yes, sir. There was a notification in the newspaper to adjacent owners, as well as posting of the property.
And have there been any public comments?
Not for the variance. We did receive public comment from the Civic Association regarding the site design, which they recommended in favor.
All right, questions from my colleagues?
No, Mr. Chairman.
No, it's pretty straightforward, self-explanatory. Thank you.
Dr. Shannon? Oh, she's not in, sorry. She's recused. So, Mr. Smith, the justification for maintaining the existing setbacks for the existing structure is obvious. What's the justification for using the same fairly dramatic variances from the setbacks for the addition?
Certainly, Mr. Chairman, in the R2 NC district, unlike others in the city of Annapolis, rearward expansions are permitted to maintain existing side yard setbacks. So as originally approved with the 3.5 left side yard setback and the 0 right setback, the addition was approved with those setbacks. As Mr. Sullivan indicated, this is really the exact same application that we already approved, except we're replacing the existing structure, hence the variances. So we felt justified in the same thing.
Okay, I understand that. Let's see. All right. This hearing will be continued until June the 15th. In order to give an opportunity for public comments on any of the evidence that's been heard this evening. And on June 15th, if everything goes according to plan, we'll have a decision for the applicants.
Thank you.
So thank you very much. And we'll see you on June 15th.
Okay, thank you.
Thank you.
All right. Julian, would you like to bring in special exception 2021-008?
Mr. Chen is back with us as well.
We've got the pleasure of Ms. Rouse's company on this one. Good. Okay, are we here? Are we expecting anyone from the applicants?
You have a few people on for this. You have Mr. Dales, Ms. Arnall, Ms. Espinoza, Mr. Meekins, Mr. Bradshaw, and Mickey Bocol.
Sit down.
All right, is everyone in now, Julian?
Yes, sir.
Okay. All right, we'll now turn to special exception 2021-008. Special exception for the establishment of a fast food restaurant with carryout and delivery at Georgetown Plaza on Bay Ridge. Last use of this property was a different fast food restaurant, but the authorization for the use apparently has lapsed for failure to use it. So we'll everyone who proposes to give evidence on this application this evening, please listen and affirm or not this oath. I swear or affirm, subject to the penalties for perjury, that any evidence I may give in this matter will be true and correct to the best of my knowledge. So we need an affirmative response from anyone who plans to testify tonight.
Yes, I affirm.
Affirm.
All right. So Ms. Rouse, is this yours?
Project, yes, sir.
Would you like to tell us about it?
This is a proposal by the owners of the property at 914 Bay Ridge Road, which is called Georgetown Plaza, to establish a fast food restaurant with carryout and delivery, as you previously stated. The application is actually began over a year ago as a building permit submittal by a fast food restaurant chain, Domino's, and the building permit was denied because the use required a special exception approval, and it also required a traffic impact study. And I've gone through the detailed history of this, what happened last year as the application. It did not really actually move forward with its traffic impact study until the fall.
Oh, let me interrupt you. I'm sorry. Julian, can we bring Ms. Chen back in for this, Dr. Chen?
Dr. Chen is here.
I'm here.
Oh, great. Thank you. Sorry. All right. Sorry, Jackie, please
So
continue.
there was a substantial delay in the processing of the application because the Dr. Nash, our former director, had engaged in conversations with the proposed business owner about a traffic impact study, but that was not commenced because until the fall, and that was, as I understand it, because they did not pay for the study, and that had to be paid. And then we don't do traffic impact studies in the summer when schools are closed. So finally in September, the traffic impact study was completed, and it was our understanding that the business owner was going to submit a special exception application, but that was not forthcoming. And finally, in December, the property owner submitted this application, which we began processing at that point in time. There were some issues related to the processing of the application. It's located in a two-story mixed-use building, and one of the things that we look at is whether or not all of the tenants located in the building, everything is legal there. We discovered that there were some tenants who don't have use permits and still don't have use permits, but eventually there were some issues with whether or not there is actually sufficient parking on site to support all the uses in the building. But we eventually agreed with the property owner's representative that we would allow the application to move forward and put a condition on it about bringing themselves into compliance with the city code for the requirement for use permits for all the tenants before we would approve any building permits to move this specific use forward. And we also have an agreement with them that because for whatever reason, there is not sufficient parking to support the utilization of all the vacant space in the building, that they will, and I think we sent you these floor plans that show that a certain percentage of the space in the building has been marked storage. We will finalize all of those numbers also as a condition of approval of this application. There's still, as all the tenants at this point in time do not have use permits, we haven't been able to totally finalize all of those numbers, but we feel that can all be worked out as part of the process, all prior to the issuance of building permits. And the building permit for the specific tenant, if they still desire to move forward with the project, has been held in abeyance. They never submitted a signed application for this. And so therefore, we also agreed with the property owner that we would advertise this as a generic application. It's really a fairly straightforward application other than those of those problems. There was no mitigation required as a result of the traffic impact study. They're proposing to locate in the portion of the building that was formerly occupied most recently by Jerry's Subs and Pizza, but a number of other restaurants occupied that space prior to Jerry's Subs and Pizza. And that's the space that they're proposing to remodel. They are proposing to have 16 seats, as well as carry out and also to offer delivery service. We have, we've recommended a couple of conditions on the approval, including designating specific spaces in the parking lot as spaces to be used by the delivery trucks, the delivery vehicles that they have. That's consistent with recommendations we've made with other restaurants with delivery service. There were no, there have been no, in the agency review, it's gone to a number of agencies review, and there really were no specific comments about the project that can't be addressed as part of the building permit. And I think that pretty much covers the basics on this. Do you all have any questions?
We'll ask to hear from the applicants in a moment here. I will ask you if there's been proper notice and posting. Before I ask you, let me say something. Members of the board have been copied on some emails, apparently in exchange between the city and counsel for the applicants relating to, I guess, whether the sign posted on the property was sufficiently visible. If the board has to make a decision on whether there's been adequate posting or notice, the decision of the board will be based on evidence that we hear tonight. I'm going to disregard the copies of the emails that I saw and ask my colleagues to do the same thing. So when I ask you, Ms. Rouse, whether there has been proper notice and posting, what I'm asking you for is the city's position, the position of the Department of Planning and Zoning, as to whether the actions taken by the applicant regarding posting a notice comply with the rules. If they don't, then the board's going to have to hear evidence on that and make a ruling on it. We only take up the issue if it appears that there's a problem. So let me ask you now, what is the position of the city as to whether or not there's been proper notice and posting?
I have asked Mr. Smith, who's the chief of current planning, to respond to you on that topic.
All right, Mr. Smith.
Mr. Chairman, members of the board, thank you. Section 2110.020A1 of the city code speaks to notice posting on the property. That's the subject of an application at least 15 days prior to a decision on the application in a manner prescribed by the planning and zoning director. And that manner is typically sent to each applicant in a form of requirements and procedures, which include examples and affidavits. And what that says, the last sentence in paragraph 1, the sign needs to be posted securely in a conspicuous location on the property so as to be legible from the public right-of-way. And I would entertain, at least from what I saw, legible from the public right-of-way.
You're breaking up, Tom. You want to repeat that last sentence or two?
Yes, sir. Did you hear what I stated in the city's?
Yeah.
Okay.
Your conclusion was.
So following that, I was party to the emails that you mentioned, Mr. Chairman, and photographs, and it did not appear that the sign was legible from those documents from the public right of way. I did not, however, go to the site myself, only from those documents I received.
All right, before we get any deeper into this, what was the, can you tell us what you considered the public right of way?
The public right of way in this case is Forest Drive, or I guess it's Bay Ridge Road at that point. That is the quote public right of way. And typically, as a pedestrian or as a motorist, you should be able to read that sign from that location, be it the street, the sidewalk that's in the public right of way.
And so, as I recall, in front of the building, there's a driveway, a travel lane, and some parking. And then there's also a walkway basically right up against the building. Is that correct?
There is a parking lot, yes, sir, a sidewalk, and I believe there is a landscape buffer between the parking lot and the public sidewalk.
Yeah. And so did you make any determination as to whether it was visible from the parking lot or the driveway or the sidewalk closest to the building itself?
I did not, Mr. Chairman, because historically our interpretation of a public right of way is just that. It's where the public travel lane occurs.
So if I'm hearing you, you're saying it's the position of the city that notice posting has failed because it wasn't visible from the public right of way.
It's my understanding the sign has been relocated to the grass landscape buffer close to the public sidewalk.
But not for a long enough period.
But not for the required 15 days. No, sir.
How long has it been there?
I would defer to Miss Rouse. She may know more than I do. Or Mr. Dales.
Let's hold off on Mr. Dales for the moment.
Jackie, do you know how long it's been relocated?
I think we had an email from Mr. Dales yesterday morning, and it was, I would assume sometime over the weekend, but he can give you the specific.
All right, okay.
Relocated.
Do we have any public comments, Mr. Smith?
We didn't receive any public comments on the project, no.
Okay. All right, Mr. Dales, you know our admonition here. We've read everything carefully. And so we want to hear from you, whatever you think we need to know that hasn't been covered or you think needs special emphasis, and particularly address the adequacy of the posting.
Thank you, Mr. Gallagher. So I understand you to be asking me about the public posting, just the notice issue.
Yeah.
And you had mentioned that you're going to make decisions based only on what we discuss here and not any of the emails that were traded and forwarded. So I should cover any of that if I want you to consider it. Is that right?
That's right.
Okay. Well, let me start by sharing my screen. This is as a preliminary matter for Mr. Gallagher and Mr. Walsh. This is I'm also familiar with Ballymaloe.
Oh.
Be going back in a couple of weeks, and I will ask them about their special exception proceedings when I get there, how long they've had it in place. But I also want to show you the photos that I took of the sign before it was moved with my feet on the public right of way. And I think they show that it was
defined by Mr. Smith.
As defined by Mr. Smith, and I'll say specifically on the public sidewalk, and then on the portion of the drive aisle that is within the public right of way. So that means not the drive aisle that's on the private side of the property line, but in line with the sidewalk. So let me find that here. And just in the way of background, the sign was posted on the day before the notice requirement would have begun for this hearing, and therefore well ahead of time for the public to have been notified for our second hearing that's required because of our virtual meetings rules. And on that day, when we sent the photos, Ms. Rouse questioned where it was, thinking it might have been on the back of the building, and it's not, it's on the side. We located on the side because there's a tent in front of the space for Main and Market to have its outdoor dining. And so locating on the side, being sure that it was still visible from the public right away, we responded. And when Ms. Rouse questioned that, I asked if she'd like us to move it up to the front. In my view, and I think the board should consider that locating the sign on the actual space for the special exception is more informative to the public as to where a special exception is being sought. And that's part of the reason we located it there. But we were aware of the rule that it needs to be legible from the public right of way. And so this was the one place that we thought would address both concerns. And Ms. Rouse did not tell us if she thought we should move it or not. And if she had, we were happy to move it up, but with no direction on it. We didn't think of it again until apparently there was an anonymous phone call asking about it. And so I went out to the property on this past Sunday and took these photos. So this is taken with my feet on the sidewalk. I could see the special exception application words from where I was standing. I think this is clear evidence that we've met the notice requirement for posting. There's some other photos. This is another angle. The angles that I think the city had been concerned about and that Mr. Smith may have seen have that pillar blocking the hearing sign. I think if you were to be several steps closer to the intersection of Forest and Bay Ridge, you would have this blocked. But if you stood here in the public right of way, you can see it again here. And I would proffer to you that this was the best place to put the sign. We only moved it because we had continued concerns when I asked about it on Monday. And so we thought we might as well go ahead and bring it closer to the public right of way. But we are firm in that we've met the requirements here and that this is in line with many of the other postings we've ever done, and we've not had a question as to whether it's met the requirements. So these are the photos I would ask you to consider. Also ask you to consider Mr. Smith said he did not see this in person. And so with the evidence before you, I would say that we have met the requirements.
Let me, with this particular photo, because of the perspective, it's not apparent to the viewer where you were when you took the picture. It looks like it could have been taken with a long lens from anywhere. Let's see the other one again, because I think you can see a curb or something in it. You had another one that was taken, looked like it was taken. Yeah. Okay. So where was that taken from? Go back.
These two are taken from the portion of the drive aisle where you are in line with the sidewalk. Now I could pull up an aerial view to show you where I was with my cursor, but it's in line. It was in the public right of way by Mr. Smith's definition.
Bill, if I'm not mistaken, that's on the side of the building that faces a parking lot.
That's correct. So the to the right, where if you can see
well, technically in the right of way, you're not. If you're driving or walking the right of way, it would be to your right, not in plain view. Correct?
No, this is me standing in the public right of way, looking at the side of the building in plain view. So, I mean, of course, if you move backward or forward on the right of way,
let's just say, for example, if you're by the exit for Georgetown Plaza, you'd be looking, possibly catch it just as you're going out.
This is taken from the exit, and the other photos are taken from further back on the sidewalk, closer to the gas station.
Well, what about closer to the entrance side over by by the design place?
If you moved closer to the entrance, eventually you wouldn't be able to see this side of the building, but the requirement isn't to be able to see it from all points of the public right of way. It's from the public right of way. And so for any point on the public right of way past the exit, which is a significant amount of the public right of way, this is clearly visible and legible.
All right. Questions from other board members about this particular notice, this posting issue? All right, Mr. Smith, do you have any photos you want to show us?
I do not, Mr. Chairman.
We had emailed you the photos that we had taken of the sign, and I did not realize that you would want us to put them up on the screen tonight. So
we don't want them, Jackie.
Excuse me?
Never mind. Sorry.
I would say that this is the side of the building, and you cannot see this sign clearly if you are actually standing on the public sidewalk in the right of way. I think there may be some confusion here about what we consider to be the public right of way and what Mr. Dale's interpretation of that is.
I'd like to address that with a aerial, because I don't think there's any confusion.
Jackie,
Yeah, go ahead. Go ahead, Mr. Dales.
I mean, I think there's an infinite number of places where it's not visible. All we have to establish is that it was visible. And I think hopefully with this next aerial photo, we'll get there.
Oops, sorry, the 914 address brings up the wrong part of Bay Ridge. Bring it up.
Yeah, it does. That's annoying.
Yeah.
Mr. Chairman, can I make a point of clarification?
Sure.
We keep using the term visible and it actually is used legible. I think it's two very different things. I think you can probably see the sign visibly, but can you actually read it?
Well, that's Mr. Smith, all due respect, it's very subjective on someone's level of eyesight. I could read it. I'm not sure everyone can read it, but that's not the requirement. So legible, is it's visible and the letters were clearly visible and legible from my photos. So let me please just proceed with so this is the exit and the public right of way would be this sidewalk where I'm sorry, are you guys able to see my screen?
No.
Not yet, no.
All right, let me switch. Okay. Is it visible now?
Yes.
Okay. So the public right of way would be this sidewalk is the closest public right of way under Mr. Smith's definition.
Yeah.
And that would extend across here. So this is the strip, the exit that Mr. Walsh was referring to.
Yeah.
I would agree that anywhere beyond here on the public right of way, you wouldn't be able to see the sign, which is approximately right here where my cursor is. But that's not the requirement. The requirement is from the public right of way. So I'm testifying under oath or as a member of the Maryland Bar that I took those photos from the public right of way and the sign is visible and legible. So I took the one photo from here where my cursor is. I took another photo from approximately right here. So the angle that you're seeing with where the letters are more plainly facing you is from this point in the public right of way. I could have equally well taken it from anywhere along this segment here. But here and here, you can get partial obstruction by the pillar. But in all these points on public right of way, which is the requirement, the sign was visible and legible as it was from right here.
So Mr. Dales, can you confirm that you did not use any zoom function on your camera?
I don't think it would have been without zoom. It wouldn't have been a very meaningful picture. I can show you. I mean, I didn't use high zoom or anything. It was a cheap camera I bought 10 years ago. I just sort of focused on the picture. Let me pull up the photos again and show you with.
So you did use a zoom function.
Yeah, Dr. Chen, for reference, I always use a zoom function when I take pictures and notice signs. So that's
So
not
that makes it, so for me, Mr. Dales, it's difficult to interpret the photo because it can be legible with a zoom function and not legible without one.
Well, I understand that concern, Dr. Chen. I took the photos to provide the best reference I could for you all, knowing that this might be an issue. I'm also testifying that it was without zoom, legible and visible for me where I was standing taking those photos. Taking it without the zoom would have provided, I think, also a very difficult piece of evidence for you to interpret as to whether with a naked eye it was visible or legible or to a sufficient.
Could we
I
have?
understand.
I have
Thank you.
one further question. So, Mr. Dales, on Sunday, you also moved it to another location.
No, Mr. Walt, I moved it on Monday because after taking these photos, I contacted staff and I sensed there would be continued resistance. And so having already asked this before and not gotten an answer, I just took it upon myself to bring it closer to the right of way at that moment. And so now the sign sits near the bus stop, but in the grass immediately adjacent to the sidewalk.
And just on your cursor, can you show me where it is?
Are you able to see the maps, the aerial still?
Again, yep.
Okay, it's approximately right here, I think.
So visible and legible right there on the right of way, correct?
That's right.
And
Mr. House or
Mr. Walsh, just to respond to that what I sense as the question there. I was hesitant to move it here and did not get any direction to do it because when you place the sign here, it only says there's a special exception for this full property. We placed it here to give the public an indication of where they actually is proposing, where we're actually proposing a special exception. So that's why we moved it.
Okay, either Ms. Rouse or Mr. Smith, can you indicate, I know you can't use Mr. Dale's cursor, but you can direct him, where you were when you looked at it and concluded that it wasn't legible.
So I parked in the parking lot that's, where you see that little blue dot on the parking lot. I parked in one of those spaces and I took pictures with my iPhone, and I began at the corner of the property that is closest to Cypress Road, which would be to your left on this.
Mr.
And
Dales, can you move your cursor and have her tell us when you're getting close?
that would be where, see where that red car is in the right of way? It's at that end of the property. I took a series of 3 or 4 pictures walking along the sidewalk to the point where the exit is from the parking lot. And what I could see in all of the pictures that I sent out to you all on, I think it was Friday, was that the sign was in the window that's at the corner of the building, and in between that sign and the parking lot is a post, that red shrub, a post office box, and a UPS box, and you could only see a portion of the sign. You could not even see the entire sign from any one of those points. That's what I saw. And that, I was not able to read anything on the sign unless you couldn't even see the entire sign. I do agree that if you are in the parking lot and you are like where those 2 cars are kind of parked parallel with the building, that you would be able to see the sign if you were any place in there. But also if cars are parked in any one of the parking spaces that are along the street, they would also be obstructing your view of the side of the building. And I think there were at least 1 or 2 cars parked there, so those are my impressions of what I saw and what I took pictures of.
Ms. Rouse, could you see the large notice lettering at the top of the sign?
I don't remember being able to see that. I remember being able to see maybe like the right third of the sign.
But you didn't.
Say that we have, and Mr. Smith can speak. I asked Mr. Smith to speak to this because we discussed this among ourselves, and we require with projects that are located in a multi-use building that the signs be posted adjacent to the right of way so that they're clearly visible from the road. We also require that, if something had 2 fronts, we would require there to be signs posted on both streets. An example that Mr. Smith and I discussed today was the Eastport Shopping Center, where we actually required public notice signs to be posted on all four streets abutting the property. The purpose of doing this is to make sure that the public is aware that something is going on the property, and that there's a notice of hearing sign or a public notice sign in some cases.
Mr. Chairman, they provide us with the signs. We don't get to choose how many signs they provide us with. In the county, they provide us with multiple signs. In the city, we get the number of signs they give to us. In this case, 1. We would have been happy to post as many signs as they had given us after the over a year process we've been through. We would have happily posted them all over. We just got the 1 sign and put it in the best place. I believe my photos contradict the assertion that you could not see the sign from the right of way. I don't know. There's evidence in the record showing that the sign was visible and meets the requirements.
All right. Any other questions from the board on this notice and posting issue?
Mr. Chairman, may I?
Yeah.
I'm sorry. I think there are some Google Street View images that may be helpful to the board. If I could pull those up for you.
Yeah.
I believe Julian's going to assist me with that. Thank you, Julian.
Okay, there's the bus stop.
I think this is one. I think there was another one a little further. So this may be about where perhaps Mr. Dales, you took your photograph.
So Mr.
It's
Dales.
close. No, I was closer. I was in the portion of I was a couple places, but here, roughly where that arrow was, where currently the directional arrow is, I was approximately there for one of the photos. I took additional photos to the left, screen left, both in front of and beyond the bus stop.
And let me ask you, Mr. Dales, can we go back, Julian?
Yep.
Move down the road a little more. Okay, stop there. See, Julian. All right, stop. All right, Mr. Dales, you see the little knife and fork above the?
I do.
Is that
It's
the
hard for me to
opening?
tell. Sorry,
Is
Mr.
that
Bell,
the
go ahead.
opening?
You can
through
zoom
which-
in if you want. There you go.
Is that the opening through which you saw the sign?
Yeah, I think where you see that reflection on the white car, this looks very similar to the view that I had. And it was very easy to read the public notice words. There's no question to me that you could read it.
All right.
And I would just state that it's frequently the case that where we post the signs could be blocked temporarily by someone placing a vehicle. And none of the shrubs here, these shrubs that Ms. Rouse referred to, are visible here. They're tiny. We're blocking the view. And we can't, the sign might get temporarily blocked by a mover or by a truck or a car in any case. But I don't think that's contrary to the public notice requirement.
All right, any other questions from the board on this issue? Okay, Mr. Dales, is there anything else you think we need to know about the application?
No, Mr. Chairman, I suppose if you're having to decide the notice issue preliminarily, I think we should decide that and then go to the merits, presuming that we're able to move forward.
Well, we'll decide that later. We'll decide that tonight, but not right now. Is there anything else we want to know, that you want us to know about the application?
Would you like us to just present our case in chief, Mr. Chairman?
As briefly as possible, please.
We do kind of have to address that for the record in case of appeal to Mr. Chairman. I'll be as brief as I possibly can. But, if we're able to.
Please don't repeat anything that's in what you've submitted.
Understood. We're not going to. That's usually how I proceed, Mr. Chairman, is to refer to our the materials that we submitted. In this case, the reason I need to do supplementary testimony is that the initial parking materials were disputed, and we went back and forth with the city as to a solution to ensure that there was available parking. And so on that issue, at least, I'll need to address the parking requirement. So with that said, I'll do it.
Why is that, since the city's recommending approval?
Well, because the city's staff report, although it does recommend approval, is, I think, extremely unclear as to the parking situation.
Well, it says that there's going to be a condition that will address it.
Yeah, I think the condition refers to the affidavit they asked us to file, which is good and is something that we can explain if you'd like. We don't have to explain it. But what I'm saying is unclear is the number of spaces at issue that the affidavit refers to, and I at least need to clarify that.
Well, as I understand what has been recommended by the city is that they can't sign off on the condition until the other uses have been nailed down. That's going to take a little.
Yeah, I don't believe that's the condition. My understanding is that the condition is that the affidavit has been submitted to recognize those other vacant spaces do not have available parking to fill all of the spaces. And so at the moment, the affidavit refers to those spaces to be labeled as storage and therefore having 0 parking spaces associated with them. that allows this application to have more than enough parking to go forward at the moment. The staff report also discusses the need to check the final parking counts with the construction permits at the time that we're building this thing out, to ensure that the use permits for the rest of the center are consistent at that time. At the moment, we have a twice revised tabulation of existing tenants and parking, which I'm happy to show, which shows that there are 125 spaces needed for the existing uses and 142 total spaces. We propose that there are 8 spaces required for this special exception. The city asked for 11, which I believe is incorrect. And so the need to provide testimony relates to these details, Mr. Chairman.
All right, we'll hear whatever you think we need to hear on the 9 versus 11.
Okay. I think I also need to present the tenant list to show the relevance of that 9 versus 11. The issue on the 9 versus 11, I would ask, I think that would be a good question for the representative from Domino's to discuss, and I would bring up a site plan when I share my screen here, or a floor plan. Actually, let's see here. Okay. So Ms. Arnold, could you just briefly state your name, address, and position for the record?
Yeah. Hi, my name is Jessica Arnell. I'm a strategic real estate manager for Domino's. I'm based out of our World Resource Center in Ann Arbor, Michigan.
Okay, thank you very much, Ms. Arnold. So is this an accurate floor plan of what we're proposing for this space?
Yeah.
Thank you very much. And is it true that there are 16 proposed seats here?
That is correct.
Is there any area that's designated as area for the customers to stand and eat their food? I don't see any.
No, not to stand and eat their food.
All right, thank you. And is it true that you will have 6 drivers and vehicles owned by those drivers, not by Domino's?
That is correct.
Okay, so Mr. Chairman, that would result in a requirement for 8 spaces based on the 30% of the seating, and 3 spaces for the drivers. It would be 5 spaces for the 16 seats, 3 spaces for the drivers. The city has added standing room requirements. I think based on your recent discussions on the Adams property on 4th Street, we've heard the position of the city to be that standing room spaces are for areas designated on the plan as standing room, and not just for anywhere someone might stand. There's not any space in here intended for, or that would be permitted for a customer to come and stand and enjoy their food. So, or even a soda or anything like that. So I would propose that it is a 8 space requirement. And the other, for context on that, to make this meaningful, I would also share the most current parking tabulation, which I think is very clear, and it relates to the affidavit. These are the various occupants, and the spaces which are currently vacant are listed here. Now I could ask Mr. Mark Bradshaw to testify to this if you'd like, or I can just proffer it. The total requirement that you see at 133 includes 8 spaces for Domino's, as you can see. So 133 minus 8 is 125. There are more than sufficient spaces here. The condition, again, I don't think requires, it's to ensure that this is accurate is the requirement. And we certainly are able to provide that, as we're moving through construction after an approval.
Okay, let me hear from the city on this issue. And if you could keep your screen share up, Mr. Dales, that might be helpful.
Yes, Mr. Chairman.
But should we go back to the floor plan? Jackie, do you want to address where you find a need for the others?
I think we should go back to the floor plan. So the code requires, this is a fast food restaurant which has a substantial portion of its business, the carry out of foods to customers. It also offers delivery, and it also does have some limited seating for people to eat on the premises. With a fast food restaurant, unlike with a standard restaurant where you have an area where customers come into the restaurant to pick up food, we require and have with every fast food restaurant that we have processed for the last, say, 40 years, that the area in front of the counters where customers are coming and picking up their orders that they may have pre-ordered or order food and taking it out, that's called standing capacity. And we require that there be a parking requirement computed for that area. And on the floor plan that was submitted with the application, you will note there is even an area, if you see where the counter is along the front, and then there's like a little box in the middle of it, that's actually an area where I think they have some kind of raised platform where children can get up on, that they can climb up some steps, and they are there waiting also for food with their parents, I would assume, or whatever. So that is how we calculate parking for standing capacity. In this case, what we have done is we have designated an area approximately 3 feet in depth, the length of the counter, where people can come and stand to pick up and carry out food and compute. And then you divide that by 7 square feet per person, and then you compute 30% of that. And that's the formula for standing capacity. And that's why we required 11 parking spaces with this use.
Okay, so Mr. Dales, can you flip to the spreadsheet?
Could I also just say about the spreadsheets? Yes, we appreciated the fact that we did get these spreadsheets from the applicant. But as I previously stated, not all of the tenants in this project currently have use permits. There are still tenants without use permits. And so we will do the final parking tabulations for those uses that do not have use permits when we get the applications, and then we apply the parking requirement formula. It may very well turn out that this is absolutely accurate, but because we do not have use permits for all the tenants, we are not able to say that this is 100% accurate at this point in time. I did discuss this with our zoning enforcement officer today to make sure that she has not heard from the property owner or the tenants with submittals of use permits for the missing ones and the scheduling of inspections. We hope to have that process finalized sooner rather than later, and it should really not delay the approval of building permits for Domino's, but it is still not a totally resolved issue with this project.
But so you don't know that there's, putting aside the 8 at the top, we know you have a dispute there between 8 and 11. And you don't know that there's anything wrong with the rest. It's just that you can't know until you have at least use applications from those properties where you don't have them.
Applications will specify for each
Okay.
tenant in the building, the type of use, the parking requirement for that use. And then
Okay, all right, Mr. Dales, you also represent the owner, is that right?
That's correct. This application is actually on behalf of the owner, although we also do represent the prospective tenant here.
And the owner doesn't require its tenants to have use permits?
This owner is not always done the property, and so I'm not sure what the prior owner did or how those uses had translated over to this current set of tenants. But we built this tabulation with the use permit data that the city gave us, and we're happy to get all the use permits necessary before the before the use permit for this is issued. And that's a fine condition. We can deal with that. We can get the use permits issued. And even frankly, whether the city decides to require 11 instead of 8 spaces, although I think that would be inconsistent with recent address of this very specifically, and this issue is not different in the code from a fast food restaurant or a restaurant standpoint, it's the same exact language. Even then, we have 17 available spaces here and only 8 required. So we've been back and forth on this for so long, and this is the, after bending to every request, this is the tabulation. And again, we are fine to obtain use permits consistent with this. So, Mr. Chairman, I think that does, at least for me, as what I needed the board members to understand about the specifics on this parking issue, that I think there are more than enough available spaces. We've provided the affidavit. We're fine with the condition to get use permits if that's what the city wants. We're even fine with the requirement for 11 spaces instead of 8. But in every instance, we feel as though we've complied with the parking requirements here.
But what you don't agree with is the number of spaces that, okay, never mind.
Well, Mr. Gallagher, we don't agree with that, but we will concede to it. Mr. Bradshaw has authorized us to work on some future parking adjustments to this, and we'll handle them in that work. So we'll even concede to the 11 spaces, although we don't agree. And so that's what I wanted to say on the parking issue. If you'd like me just to make a brief statement about the rest of the criteria, I can do that instead of calling others on testimony.
Yeah, go ahead, do that.
So, Mr. Chairman, members of the board, this is what we would have hoped to be in the city of Annapolis, one of the most straightforward special exceptions I've ever seen. It's a pizza restaurant with fewer seats than the former pizza restaurant in the same space, requesting to occupy an existing building that's already developed. It doesn't put any burden on our environment or our infrastructure. And more than that, I think it's important for the board to know that this is simply a relocation of an existing Domino's location across the street. They're just trying to move across the street. And frankly, there really should not have been a traffic analysis imposed on this project. They did that before I was involved. It's gone a long time, and we've addressed all the other criteria in our statement. Domino's has high standards for all the other things that the restaurant is required to meet for the special exception. It will be operated according to those professional standards. We hope that you have reviewed the statement and agree we meet those criteria. And we hope that you'll understand and think of the context of this application as a very simple request to occupy an existing space with the same use that was previously in it, on a site that has ample parking, even subject to conditions for use permits and a higher parking requirement than we would agree to. We'll concede to all of that. Please just consider our application and the criteria that we've addressed in the appropriate context, and we'll be here for any questions you may have.
Okay. Okay. Any questions on anything related to this application from other members of the board?
Just one question, I have, Mr. Chairman. Mr. Dales, just clarify for me the drivers. 6 drivers, they own their own cars?
That's correct, Mr. Walsh. So it's 1/2 space per driver.
And this, are these drivers, are they Uber? Are these,
These are employees, Mr. Walsh.
They're affiliated with those types of, DoorDash and things like that?
No, Mr. Walsh, these are employees. So the code requires
okay,
1 space for any restaurant-owned vehicle or 1/2 space for an employee-owned vehicle.
Does Domino allow these outside drivers like Uber Eats or DoorDash to operate through their facilities?
I think you see Ms. Arnold indicating that's not the case.
Yeah, I'm sorry. No, we do not. We do not allow any third parties to deliver our food. It's against our standards. They're only our employees.
Great, thank you. Thank you, Mr.
Dr. Chen?
No questions.
Thank you. Mr. Zazali?
I'm satisfied.
Okay, here's my suggestion. I think I'm going to use my scheduling authority as chair to continue this, not to June 15th, but to the July 2nd meeting, July 5th meeting, whatever it is, the first meeting in July. And the reason I'd like to do that is because I'll be prepared to recommend to the rest of the board, should they see fit to follow my recommendation on July 5th, that in light of the fact that the sign has been posted up on the street for more than 15 days before the resumed hearing. But there's been substantial compliance with the notice requirement. I do give deference and respect to the city's interpretation of its own rules, and that's why I'd make that suggestion. And then we will have a final decision for you on July 5th.
Mr. Chairman, as a point of clarification, because of the virtual hearing rules, we would have our final decision on July 15th, you said?
On July 5th.
Oh, 5th.
Yeah, it's the regular meeting in July. Isn't that right, Jackie, the 5th?
Regular meeting, first meeting in July is July 5th. And one of the issues that we were going to discuss at the end of the meeting is to ensure that we have a quorum.
Yeah, okay. We don't need to go into that here.
Mr. Chairman, because of a scheduling issue for me, I would ask if that's your recommendation, you please consider that I myself cannot be here July 5th. I'll be in Ireland. So if you have questions, I could answer them now and have an associate fill in, provided that the questions in substantive matters have been dealt with here while I'm here. So please consider that.
I mean, I think they have. I think we've had all of our questions answered.
Okay, thank you.
Typically, as you know, typically we don't take evidence at the resumed hearing. We just make a decision. So are my colleagues comfortable with that?
I am.
As long as the applicant doesn't have any objections, I'm okay with it.
Sensing the majority of the board, I'm not going to object to any of that.
Right, good. Well, I think that wraps it up in this case for tonight. And we'll see you all on July 5th. And thanks very much for your answering all our questions and a straightforward presentation.
Thank you, Mr. Chairman.
Thank you all.
All right, thanks.
Thank you.
Okay, Julian, you may excuse these nice folks. So we all know the next meeting is the 15th, June 15th. And we need to have Christian and Michael at that one to make sure we deal with the was it Chesapeake Street?
Mhm.
The first one was 416.
The variance.
Yeah.
Chesapeake Street, yeah, 416.
And then we need to make sure we've got at least 3 of the 4 of us here tonight on July 5th to handle that. Anybody see a problem with July 5th?
No.
Good. Okay. Well, that sounds good. Jackie, are you good?
Now, meeting invite that, we encourage you all to hit the yes button.
Yeah. Yeah, we will. We'll learn to do that. We're trainable.
I know you all are trainable, and we're also going to learn how to merge the invitations so that the Zoom information apparently there's some magic process where when Kim's invitation can be merged with the Zoom invitation.
Only people under 40 can understand that.
It's some magic thing, so.
We destroyed that possibility.
And we were doing all of this for Christian.
All right. Any other business to come before the board tonight?
Motion to adjourn.
Is there a second?
Second.
All in favor?
Aye.